exactly 3 o'clock in Johannesburg, South Africa. Good afternoon, everyone, and good afternoon to our esteemed panel. Thank you so much for joining us. And to the audience at home, thank you so much for making time out of your day today to just join us on this exercise. As we round off Jazz Appreciation Month, a lot of activity has taken place, demonstrating the dynamic times we live in as creators, as buyers, or even consumers of content. The concerns about the status of the creative industries continues to grow amongst everyone involved in the sector as jobs are lost and funding is becoming even harder to generate. This month of April is a big month for the music fraternity, particularly for jazz music. It marks the 10th anniversary of International Jazz Day, which takes place on the 30th of April. It is also WIPO's World Intellectual Property Day, which is today, the 26th annually. And most significantly, in South Africa, it is Freedom Day, the 27th, which is tomorrow. As the Spain Foundation, through our International Jazz Day Dialogue Series, we've been hosting seminars to investigate the nature of this business we are in. And today we're going to focus in particular on the nature of copyright as it pertains to South African music. Intellectual property, by definition, is the creation of an idea in the mind of an individual, where copyright is the protection extended to the originator of the idea. So says WIPO. Due to South Africa's complicated past, the complexities of this subject seem to tangle up even more with the digital activations dominating the scene. But today, with the help of an expert panel, we hope to bring the focus back to the question of copyright and IP in this future we're living in. We are grateful for the participation of Ambassador Nonzipo January Badel, a notable proponent of human rights across diverse industries, Dr. Tijoke Okori, author of the multi-sided music platform on the law, copyright, law and policy in Africa, a great book on this subject, as well as Chola Mahamate, the chairperson of the Copyright Coalition of South Africa. And of course, facilitating this discussion is colleague, musician, Nomfundo Kaluva. I hand it over to you, Nomfundo. Thank you so much.
Thank you. Thank you very much, Brenda, for that incredible intro. I was going to request our esteemed panelists to switch on their videos and to also unmute. The mute thing becomes tricky because you mute because there's background and then you speak and you forget that you're mute. So I think we've all grown accustomed to the world of webinars. I heard someone say, that guys, please, one thing don't do, like a sort of house rules with the webinar, don't ask, can you hear me? Can you hear me? I think it's one of the phrases that we basically all just hear all the time. Can you hear me? Can you hear me? And I mean, it's an honest question. It's an important one. So I'm not going to really, give a further intro because the executive director of the Spain Foundation, Ms. Brenda Susana, has really done that already. Mine is to really just get straight to it. We were speaking earlier during our tech run, and Ambassador said something, which she said, oftentimes we think we understand these things and we don't really understand them. We think we know them. We hear the word copyright, we hear the word intellectual property, and we use these terms, but the question is, do we really understand what they are fundamentally? And I asked Chola, who I'm going to invite to perhaps take this first question as the chairman of the Copyright Coalition, whether Chola, could you perhaps bring us in, as the layman sitting here, sitting anywhere in the country right now, really interested and wanting to understand what is copyright and what is IP? Are they one and the same thing? And if not, what is the difference?
Okay. Good afternoon, everybody. Thank you for having me. And thanks, Nomfundo and Brenda in particular for organizing and facilitating. Sure, copyright, eh? Okay, let's first start with intellectual property, because that's really the umbrella. So you have this thing called intellectual property, and really, when we think of property, we think of something that's fixed, something that you can touch, something that you can hold. Think of a house, think of a car, all those things. That's what people think about when they think about property. So that would be what we call corporeal property. Then there's another element of property called incorporeal property, and that involves things like intellectual property, which is property or things that arise out of, that you've created out of your intellect. So an idea that has been put together in some sort of form, whether it be music, whether it be writing a book, whatever the case may be, but that's intellectual property or a patent. Now that's the umbrella sort of structure that I'm thinking of when you're talking about intellectual property. And then within intellectual property itself, you've got different sort of subsets of intellectual property, and copyright is one of those. You have patents, you've got designs, you've got other different things, but copyright is a subset of the intellectual property world or intellectual property sort of umbrella. And really, copyright is quite a niche area of intellectual property law, very simple but complex at the same time. That's why I think people struggle with it. And I think they struggle with it more in its operationalization than the concept itself, because what copyright essentially is that it gives you, as the creator of a work, like I said, whether it be dramatic works, whether it be literary works, whether it be a musical work, the exclusive right to do and allow others to do with your work. That could be publishing the work, that could be reproducing your work. And most of the challenges come with the reproduction of the work, because what happens is that once copyright vests in the work, it attracts a certain bundle of rights that are exclusive to you as the copyright holder or as the rights holder. And within those rights, depending on what they are. So for instance, with a musical work, you have performance rights, you've got reproductive rights, you've got a whole bundle of rights that attract to the copyrighted work and allows you particular protection, or allows you to allow people to do, or for you to do with that. And that's an exclusive right, obviously with a limited term, and you are allowed protection for those rights. You're allowed also to make money from those rights. So the economic rights accruing to that, and they also what we call moral rights accruing to that. So the right is really, it's part and parcel of you as the person. So people just can't adapt or change the work without your permission, because there are moral rights accruing to that. So you can make money from it, it can be adapted, but obviously, with your permission, or people can pay you to use your works, and therefore make money from it. But also, when that money is paid to you, then a certain amount should be also be paid to you by way of royalties. But it depends obviously on the work in question and the rights that accrue to that work. Now, on the other side of copyright is there's this balancing act that needs to be created, because you as the user, or you as the creator, sorry, have these exclusive rights that accrue to you because you've created this work. But we also live in a world where creativity, some will argue, relies on others using what you have created. And there's some element of public interest that must be balanced there, because yes, you have exclusive rights, but others would want to or need to use your works for various reasons, whether it be for commercial gain or for other reasons. So there's that balancing act between the creators on the one hand and the users on the other hand. And it's always a tough balancing act to maintain. And that's, there's always a tension there. And within the Copyright Act, our copyright and copyright acts across the world, you have what we call exclusions to that exclusive right for copyright. So, in some instances, your works can be used without necessarily getting your permission as the creator, but that's built into various legislations. In our legislation currently, it's there's a particular set of instances where you can use those works without necessarily getting permission, whether it's for academic uses, whatever the case may be, but those are clearly set out in there. So really copyright is that it's my ability as Tola. So it's, for instance, to write a song or to compose a song, and then I can use a song for a limited period of time, and I can do certain things with it, or you, Nomfundo, can then request that you use my song in whatever platform, as long as you adapt it in a manner that does not infringe on my copyright. And when you make the money from it, we have an agreement, whether it be through a license agreement, whatever the case may be, for you to use it, and then you pay me what's due to me as a copyright owner.
Earlier in your answer, and you actually, I'm glad you spoke about that. You really kind of focused on this notion of property, right? And when curating this webinar, sort of adapting this metaphor of land, right? Because IP, I would imagine, is intangible property because you can't touch it, right? And that's why I thought it would be really interesting to adapt the ownership of land. How do we think about land? Why is it that we want to own land? Why is it that we value, this asset of land? And kind of trying to think about IP from that through that framework, even if one can only do so to a certain extent. I want to then probe further to say, what is it that you think, in the work that you've done in this space, what do you think artists and creatives are missing at the very beginning? So I write this book or I write the song. What is the first step that I should do? What is the first step that I should take to make sure that my work is protected? Because I gather that we often think about copyright retrospectively, right? So if we're sitting in a room with artists or authors, right, and we say, guys, once you've created that idea, once you've visualized it, communicated it, what is the first step? What's the first step of protection?
Sure, it's an interesting question because, land is so easy. You see it, you can touch it, you can feel it, you can build something from it, you can mine it, you grow things on it. It's easy to understand that kind of value chain. Whereas with copyright, it's such a nebulous concept. And I think what also doesn't help is that the other areas of IP, so for instance, patents, designs, the rules around that are very clear. There's a registration process. There are particular legal documents that are clear to all the parties concerned. There are structures where you need to go through for registration, you pay a fee. So I think the rules of those games are quite clear. And also with patents and stuff, it's also other areas of the economy that for lack of a better phrase, that people take seriously. So, whether it be in mining, pharmaceuticals, whatever the case may be, those are the big sort of economic drivers that people see and they take them seriously. Whereas with copyright, when people think about copyright, and because of the space where it is, which is mainly in the creative industries, I think that it isn't taken as seriously as it should. And also in terms of just the rules of the game are not very clear, in the sense that registration, how do you go about it? Do you need to register? What qualifies as publication for some instance? Because if you publish, that is a form of, letting everybody know that, your works are copyrighted. So the rules of the game are not very clear. And also, like I said, because there's so many different works with so many different rights and so many different ways to gain economic value from them, I think people just don't know how to navigate the landscape. And I think, and I can't speak for other jurisdictions, but I think our jurisdiction in particular, there's also the challenge of knowledge levels, knowledge about, firstly, reading levels, knowledge around copyright itself, knowledge about contracts, knowledge about rights, knowledge about just where to go to do what. So you will create a beautiful song or compose a beautiful song, then you won't know what to do with it next. And then you use it and you haven't necessarily put the right contracts in place, or you don't know which rights you're supposed to exploit, or somebody else uses it and then you don't know what to do, what the next step is. So I just think it's not clearly articulated and defined what the rules of the game are with respect to copyright. So there's copyright affecting musical works. There's copyright affecting literary works, which books, there's copyright affecting animation. There's copyright affecting audio visual. There's a lot that lives within copyright.
Okay, that's fair. It's complicated basically, and I'm grateful that you put that point, because we think that land is more complicated, but you've spun it in a way that makes so much sense to me, to say, well, you can point at land, you can say, there it is, I can touch it. Whereas with IP, it's very different. And I'm going to bring the ambassador in here because, and I want to bring the ambassador in because of your vast experience, both within, corporate and the private sector. Working a lot, in initiatives that really drive women empowerment, working, in businesses and in very high level corporate spaces. And I want to ask you, Ambassador, I mean, in your work, in your extensive experience, how have you come into issues of of intellectual property, right? Is there a certain way in the different areas and spaces that you found yourself in where you found that it was quite difficult to register your ideas? You know, have you ever encountered that? How would you, in your world, sort of say, well, this is the role of intellectual property, whether it be in the private sector, whether it be, you know, in public sector, in corporate, in any kind of philanthropical work that you do? How have you encountered this concept of IP in your work?
Yeah. Thank you, Nomfundo, and good afternoon to everybody. This is a very difficult conversation. Let me start from there, because it's the question you've just asked me also is quite a complex one, because I have worked indeed in the public sphere and private sector, in diplomacy at the United Nations and in the private sector. And each one of them really is quite different, because most of them are driven by policy. So by the time you get into an institution, the policies are pretty much in place. And most of the time, you know, the decision makers, the politicians in the case of the private sector, have already decided what it is they want done, in the public sector rather. So one can only then take those policies and interpret them, if you're in a leadership position, in a way that accommodates everybody, if you like. And then there's a challenge that, you know, if the law then does not accommodate that inclusivity, the law that defines, let me take foreign affairs as an example, because that's the one department that I've had a lot of experience in. How does one change the foreign policy so that, for example, it accommodates the interests of women, or it accommodates the interests of young people, especially when we invite our artists to go and do a gig in Switzerland or in Brazil or wherever the situation is. And I think my personal experiences in that is to make sure that, you know, when the artists do come to those environments, they are well received, but they are also, their property is also respected, and people need to feel that they can't just do with it what they've come to entertain, but they haven't come to give it away, you know, to give away what they bring to any environment. So so my issue here with property rights and with copyrights is that the first responsibility then as an ambassador would be to protect the copyright, the rights of our South African artists when they come to another country. And if that doesn't happen, then how do we introduce legislation or foreign policy, add to the foreign policy that actually does do that? And I must confess, that is a conversation that we've never had in the public service. It's not a conversation that comes readily. It's one that, you know, somebody would have to think about. And the department that would normally need to think about that would be sort of corporate services, but it will not be across the board issue. And right now, if I look at most of our departments, I would say that from the public sector perspective, there isn't one department that really takes care of those things within that department, you know, that says, okay, our responsibility or part of our work would be to take care of copyright and issues. I mean, the case that I like to cite best is when Dr. Nkosazana Dlamini-Zuma went to the pharmaceutical industries at the time when we needed to have access to the patents around HIV/AIDS drugs. And the pharmaceutical companies were not wanting to part with their patents. But because there was a need for us to have access to that, she took them to court. She took the industries to court and she won the case, and they had to share that patent, those patents, to make sure that people have access to antiretrovirals. So that's quite a classic case law, because I think these things are also influenced by case law, where we do test the legislatures, or rather where we do the courts and see how far they are prepared to go. So I think there's a lot of protection, but often we don't know how to access it. As Chola was saying, you know, a lot of copyright is protected, but we just don't know how. And often it does require really ministerial initiatives for these things to be changed at an international level. In the private sector is much more astute to that, because they are more sensitive to the cash nexus and profits, you know. So they don't want to lose anything. So they make sure they've got a legal department which makes sure that their ducks are in a row and they can protect whatever is theirs. Copyright is not something that you'll find on the agenda of the board or of the executives, but the legal department will be the one that scrutinizes everything. So there at least is a structure within the organization that will make sure that the company's rights are protected. Very complex when it comes to land, because land is also, say for example, I was on the board of a mining company where they had to mine the commodity, but there's also something called natural assets, you know, water, the environment, and so on. So who protects that? Often it's legislation, and they need to be careful that in mining they do not contaminate water that you and me drink every day. So they had to make sure that that they stick to the rules on that, because the land is not really theirs. They're borrowing the water. They're just borrowing that land to mine, but it effectively is not technically theirs, or in the way that they have the rights to do whatever they can. They are limited by legislation, regulation, and they have to be careful, otherwise their reputations might be ruined as a result. We haven't seen enough cases of this in the private sector, as I say, because they have deep pockets and they are able to both protect their rights in a different way from individuals who are dependent on the state to take care of their needs.
It's interesting, Ambassador, when you said it, and I think it's really important and so insightful to get that perspective, in terms of, I know also you've done work with DIRCO, because oftentimes we look at at copyright from a purely creative industry perspective. Oftentimes as artists, we look at it through the lens of creative entrepreneurs, and we don't really kind of often venture out into how do people in other sectors, approach copyright and deal with issues of intellectual property, and also bringing in the fact that, in terms of legislation and policy, what drives these policies, because we're not in a country, operating in isolation, and I spoke earlier on as well during the tech run about these conventions and treaties, and I really appreciate how you kind of making that distinction between private and the public sector. In fact, it's interesting that the example you cite about Dr. Nkosazana Dlamini-Zuma and that patent, and we look on TV now and we saw the other day, IP issues related to the COVID-19 vaccine technology, right? So IP is always finding a way to sneak in, right? And to kind of hold things. And it's really quite important because, it's great that case, Dr. Dlamini-Zuma won, but we're sitting now and we're thinking, well, what are the implications of IP, for the vaccine technology, and them not wanting to, the scientists or whoever not wanting to really, share that, so that'll be interesting to follow that and see what are the implications thereof.
Yeah.
I'm going to bring in now Dr. Chijioke Okori, because Chijioke, your book, Multi-Sided Platforms, and I want to tie it into what the ambassador was speaking about in terms of policy and regulation, and making it very clear that in the private sector, it's clearer, the policies are there, it's about the bottom line, the profit, they've got their stuff in order. And I think about us and I think, what ministerial department are we going to rely on, to kind of get this kind of, protection? Who's going to handle this for us? Is it going to be DTI? Is it going to be sports, arts, and culture? Where do we begin? And I want to invite you into this because your book doesn't only look at Nigeria, but you're looking at the continent at large, right? In terms of what are the regulations around copyright, and also maybe to simplify the question, what drives the regulations and the policies of our copyright law within the African continent? Have we created these laws, or are we relying on, regulations and treaties that we've signed with other nations?
Okay, thank you for that question. Shola has already explained how copyright law works and how it affects, the creative industry. And Ambassador has talked about how, the public sector, private sector ways of dealing with copyright issues. In terms of laws, regulations that deal with copyright protected work, copyright protected content. Um, Copyright is like other areas of IP, is aligned to and aligned with international treaties. So at the World Intellectual Property Organization level, and also at the World Trade Organization level. So there's the trade related aspects of intellectual property. So whenever you're even having conversations at the international level, as it relates to trade, you would be also talking about IP and copyright, of course. And so as countries, South Africa inclusive, and as countries, in Africa, on the African continent, you don't just wake up and pass copyright laws the way you like. You would, because you're a member state to these international organizations, there are already treaties, copyright treaties, intellectual property treaties that are binding on you as a country. So you take those treaties, which of course you would have been part of the negotiation process. You take those treaties and then you come back home and domesticate the treaties into your national laws. At the international level, when you have these conversations, when you formulate and come up with those treaties, you would, at the back of your mind as a country, you would bear in mind that you're going back home to implement those treaties into law, to domesticate those treaties. So you're thinking about the lived realities of your countrymen, of the citizens of your country, and how whatever it is that you agree to at the international level is going to impact your lived realities. So I'll give you an example. On the copyright side, there's the Berne Convention that deals with literary works, musical works, artistic works, and the like. And there's also what we call the TRIPS agreement, the agreement on trade-related aspects of intellectual property. There's the Marrakesh Treaty that deals with access to copyright works for visually impaired persons. There's the Beijing Treaty that deals more with performers, actors, the audiovisual sector. So all these treaties are factors that come into play when we are dealing with our Copyright Act in South Africa, when we're dealing with Copyright Act in Nigeria, when we're dealing with Copyright Act in Kenya, wherever. And the conversation that we're having as Africans, as people who are from the African continent, is that when we have these conversations at the international level, we are having the conversation with other countries who are not at par with us in terms of the stage of development, in terms of their socioeconomic realities. And so we have those conversations, and because what we call the global north is, sitting at the head of the table as a we then come up with international copyright treaties, international treaties that don't make sense for the realities that we have on ground. Because as Africans, we have issues with having access to protected content, both in terms of from the artist and the creator side of things, and even from the public side of things. So when we come to South Africa, usually it's the DTI that is driving the conversation around reforms to our laws and how those laws then affect the things that we do. So if for instance, we are asking ourselves whether the regulatory frameworks are there, yes, they are there. We have the Copyright Act. We have the Performance Act. We have those. But the Copyright Act in South Africa is a 1978 act. It's been amended a few times, but the amendments are just slight amendments. The biggest and the most far-reaching conversation that we've had around copyright in South Africa is the Copyright Amendment Bill. And we all know where that is at the moment. So do we have the regulatory framework? Yes. Are they strong? It depends, but in terms of a country that is coming from the apartheid history with its social injustices, and you have a Copyright Act passed in those times, and since that time hasn't seen significant amendments, because the problem that we have with our past is that it is not just that we had an apartheid era with its social injustices and the restrictions and the unfair and unjust treatment of Black people and people of color in South Africa. It is also that it doesn't just affect the laws, it also affects the application of the laws, the ways the laws affect our structures. So as a Black South African going into a negotiating table to talk about, oh, the law says I am the artist, I'm the creator of this work, I have copyright in this music. You have copyright, but you're going to have conversations with people who are going to take your work from your sitting room, from your studio to the world. And you don't have the money to move your work to even leave your local environment, not to talk of coming, to the country, and then outside the country to Africa and to the rest of the world. So if you're coming onto the conversation table, you're already coming disadvantaged. You already come in from a very weak, bargaining position. So what are you going to say? You have those rights, yes, but structurally, can you? What can you do with those rights?
You're segueing directly into what I want to speak about next. Technology, okay, guys, I mean, we did say, Brenda and I did say up front that it's not our strong point. We wanted to actually play Mbube, right, while the guests were coming in. And the reason why we wanted to play Solomon Linda's Mbube is because it's the classic case of misappropriation of copyright. So for the benefit of those of us who maybe just need a reminder, everybody knows, well, by the time I was a sort of a school kid, I didn't know it as Mbube. I knew it as Awemawe, right? And it was only much later that I actually realized, oh no, actually it's Mbube, Yimbube, right? And I don't want to focus on that song specifically, but I want to focus on what that case represents in the larger scale, in the grander scale of the apartheid era, and how Black artists were dispossessed of their copyright. I don't think, we all know, obviously, that the nationalist government did not want to recognize the creative ideas of Black people in that time. And, my having studied Miriam Makeba so closely, she says in many of her works and her, and in her books, in interviews, that they would go into the studio, workshop something, whether it's herself and Mam Dorothy Masuka or Mam Abigail Kubeka, they would workshop, they would create these songs, and they would walk into the studio, while the white sort of record label holder is chilling outside, might be having a smoke, waiting for them to come up and then would basically come in and say, okay, are you ready? Are you ready to go in? And they would have to have something ready. They'd walk into the studio, record something great, right, that they've come up with, and then get a little piece of money, like just a little share of money, to say thank you for your time. Sign this before you get your money. You sign it, and then they left, never to see royalties from that particular piece of music again. And there's many. And so I was thinking in my head when I thought about this, and I thought, is it too late? Is it too late to try and track back and say, guys, wait, man, we've got so much rich African repertoire that sits in the hands of, international record labels and publishers that, Mrs. Brenda said, it's almost like we need to ask ourselves, have we had a type of TRC, right? To say this repertoire that has gone on to amass so much money around the world off the back of Black creatives who were denied, right? And you speak to Joke, you say, well, our Copyright Act in South Africa is from the 70s. And you're saying, are you kidding me? You want to tell me that between the 70s and now it has not really been amended yet? So what it says to me is that we've inherited that structural, inequality. And I want to put it to you. Perhaps I'll bring Chola in here to say, Chola, having sort of worked as well for a collection management organization, who administers rights. I mean, is it too late? Is there a tracing mechanism to say, guys, let's just take the music of this period and let's interrogate where is this copyright? Right? Yes, of course, Solomon Linda, it's a huge case. It's gone on. It was only in 2003 that, the record labels and everybody came in for restitution. But even that still hangs in the balance, right? Because we're gonna take our kids to see we're gonna take our kids to see Lion King. So this music is going to continue to create wealth, And so I'm thinking, Chola, is it too late? Some kind of retributive justice of sorts to say, even if these people no longer live, but surely their copyright should be properly or accurately captured. Or am I dreaming? It's not going to happen.
You don't ask a simple question. Because there are a couple of moving parts. I think the first one is that as Africans, we have a long, complicated history with property, generally, but also just intellectual property. Because remember, at some point we couldn't own, we couldn't own land. That wasn't recognized. What more with something like intellectual property? That's so complex. So you had a lot of situations like Solomon Linda composes this beautiful song. It becomes quite popular locally, sells it for 10 shillings. Somebody takes that, passes it on to somebody else, probably put some interesting contractual clauses in there with indemnities and whatever else the case may be to make sure that that work is locked in to a particular party, or allows only that party to then further sub-license or allow others to use, and the original composer does not see a cent of that. He dies a pauper. His heirs, despite the fact that there was the songs, the composition was supposed to revert, the rights were supposed to revert back to his estate after 25 years, they also don't see money. It then takes somebody with deep pockets to say, right, we're taking this thing on to court. Eventually they settled. We don't have all the details of settlement, but obviously he was recognized as a composer and they were supposed to be getting some royalties administered by a trust. But the story is a sad story, like you're saying. And what generally tends to happen is that even when you try and remedy it, so for instance, in terms of the recognition of intellectual property for indigenous knowledge in this country, there was the International Intellectual Property Laws Amendment Bill, which was meant to amend Copyright Act, Performance Protection Amendment Act, patents, et cetera, to take into account indigenous knowledge, and that would then have an impact on royalty payments, et cetera. The challenge is that it's not retrospective. You can't apply that law retrospectively. It can only be applied prospectively, which creates a problem. That leaves us really at the mercy of the goodwill of certain companies. I know there's been a movement in certain organizations worldwide to have a sort of TRC where you pay reparations to certain artists or composers because you benefited off of them and they didn't really see a cent of those royalties. And what they do, which I think is the evil thing, is they take advantage of the lack of knowledge around copyright, the lack of knowledge around contracts. So someone signs something that, I assign you my works for the duration of copyright, which means for the duration of their life and 50 years after their death. And then the thing falls into the public domain. And by that time, nobody has to ask you for permission or pay anybody. so even your heirs will never benefit from that, and they watch, they see people making money from that. So I think a lot of it is we need to look at, like you're saying, some sort of TRC, but I think also we need to have a deep look at ourselves as Africans, because something like that would require a level of, I think, in one way is political will to take something like that on, because like the good doctor was saying, when we go to any table internationally, we're really the small boys. And more often than not only are we the small boys, but we are so invested in our own petty squabbles that we don't fight for the bigger picture, and therefore never really get our agenda on the table. And if we have that sort of concerted effort to say, there was exploitation of these people and their works, and you owe them money, then we demand it at an international scale, I think something can be done about it. But like I said, lots of dodgy, evil contracts all over the show, some even being still signed to this day. And that requires a level of education amongst a lot of our creators about, what are their rights, what they can do, what they mustn't sign, what is unethical, what is something that should never be in a contract. So there's a lot of work that needs to be done from that perspective. But you'll find, like also with this Solomon Linda stories, that you settle and then there's a nice confidentiality arrangements around what happened, because some of the matters are not properly ventilated in a court of law. And that's the challenge with copyright in this jurisdiction in particular. Very few matters get to court, so very few things are ventilated in the copyright space in the court of law, particularly dealing with stuff like that. For instance, I would like to see precedents set around indigenous knowledge, the recognition of copyright around that, looking at IPLA and its implications and how that needs to be managed. I would like to see those types of things being ventilated and discussed openly, dealing with the exploitation of creatives, particularly African creatives.
Thanks for that, Chola. And, I appreciate your honesty to say, yeah, it's dodgy, and it vindicates me when I hear a legal expert saying it's dodgy, because I always think it's so dodgy. And to hear you say that it's dodgy, I feel like, okay, it really is. So I want to move not too far off, but to bring the ambassador in the space here, because the spirit of the Spin Foundation sort of webinar is very much unapologetically pro-women. Right? We're very much pro-women, women at the forefront, women at the table, women in positions of influence and power and executive decision-making. And so far, we've really kind of tried to bring women into the space who've got the expertise, who've got the knowledge, to say that our voices need to be amplified, because we know we do have the intellectual capacity to make these decisions. And I think about, Ambassador, I think about the creative industry in South Africa and how, for instance, the music industry is so run by men, right? And to this day, really run by men. And I want some pearls of wisdom from yourself as somebody who's an advocate of women's rights, at UN level, and all across the world. I mean, I listened to your speech when you were awarded the doctorate abroad. I think it was Glasgow or something, you might correct me. And just listening to the way that you speak and listening to your journey and knowing that, you're all about the empowerment of women. What would you say to women in the creative industry? What pearls of wisdom could you throw at us to say, try this and try that, in terms of really finding your spot and finding your spot and your voices in your respective industry? Is there anything that you could share with us to amplify our voices as women? Because it's a classic sort of, thing. We've inherited it from back in the day, that women just come in, we sing, we look pretty, we dress pretty, we sign, we do what we're told, we obey, and then we take the money that we're given, because, that's it. And I'm just thinking about a statistic actually that came out that said, that 80%, of, it's a SAMRO statistic that said 80% of the membership, of our CMO, which is our collection management organization, is 20% of are women, and only 8% of the money paid out in royalties goes to women. So I'm thinking, Ambassador, as someone who's worked in corporate, and also worked with women and women empowerment, what can we do? What can we do to assert ourselves as women in this industry? I think you're muted, Ambassador, as well.
Thank you. That's also a very hard question, but I think I'm getting accustomed to your hard questions. So very, very challenging. I think, you know, I remember us starting when we were all fighting for freedom in South Africa, and the National Women's Coalition, which really drove the process of making sure that women were central in the constitution making process, and made sure that we had that Bill of Rights that protects all women in South Africa. And we've also been very active, as you say, as Chala said, you know, in the international, and Chijoke is saying, and in the international space. With Phumzile Mlambo-Ngcuka sitting at the head of UN Women right now, lots of advocacy is being done across the globe, not just for South African women, but for women all over the world, to say, let's fight for our rights. And the thing is, our rights will never be handed over to us on a platter. Rights, as you all know, as we've been talking about them, simply give us the ability to claim that our rights have been violated. So we can make the claim using the law, but international law does not necessarily transform our societies, and in a way that makes them less patriarchal. If you see, they have a small role to play. The law, actually, when I was sitting on as a committee member of the Convention on the Elimination of Racial Discrimination, I understood that so well, because the conversations tend to be focused just on the legislation, but not on the transformation of our societies. So I think that for me, throughout that process where women were marching to say, when we reached 1994, we must make sure that our voices are also the voices that will shape our constitution. My recollection, and I might be very long, is that most of the artists who were part of that process came into that to entertain us, to participate in the entertainment value of the arts. You know, people were invited to sing, people were invited to do poetry, but I didn't hear their voices in the actual debates, in the actual concrete debates about, you know, women's rights in the Constitution. So I think in that what I noticed then was that I don't want to generalize too much. Many of the artists prefer to be on the margin of entertainment rather than in the center of transforming our society and our constitution. And so I'd like to invite the women of our country who are engaged in the arts and in the other creative arts to locate themselves, to move from the margin of their industry, of their craft, and locate themselves in the political space of transforming our society, because that's where their voices are needed. But that also requires, without being patronizing once again, you know, knowing, expanding the knowledge base, coming to seminars like this, understanding what copyright law is all about, understanding how the Department of Arts and Culture, if you like, is a weak department that needs to be transformed, and they should not be satisfied with the kind of service that they've got from that department. We are having local elections soon. Can the artists not be sitting on the margins singing songs at the rallies, but be part of, you know, why should we not vote for this person because they're actually going to give us nothing? You know, they haven't even factored in that issue into their campaigns. So really, and I'm speaking at a very basic level from the start, which is that you've got to fight for your rights. Nobody is going to give it to you on a platter. So that's the first challenge. I think there are lots of things that can be used, you know, the SDGs, the Sustainable Development Goals, Goal 5 now, that protects the rights of women and says leave nobody behind. There's lots of information in there that can be used. Education that can be shared through webinars like this. You know, you only need to ask somebody from UN Women to come and talk to you, to us about you know, SDG number 5, which really also says we need to really disaggregate women's experiences. You know, I always feel our freedom is still very masculinized. When we think freedom, it's a masculine notion of freedom. It's not necessarily a feminist one. When we talk about our national character, I still think there's a male character there. There isn't a female one in that. And I think that our politicians take advantage of that because they haven't really, there are numbers of women, we've changed numbers of women representation, but I'm not sure if we've actually got to the crux of what needs to transform in this society to make women more central. And I don't want to throw the baby out with the bathwater, but I think that when we choose women also, we need to choose women who really want to make a difference. Look at our women in cabinet right now. You know, I mean, I don't know how many of them have made a difference to women's lives, to be honest with you. And yes, women have the right to be employed, but don't assume that when they get into those positions, they're actually going to make a difference to women's lives. They're just in a job like men are, you know, in a job. But I don't, so I think that there are lots of things that we can do, that the industry, the creative artists can do to make this, the struggle for justice in their own industry much more visible, much more inclusive of people outside of the industry. But they have to lead it. They almost have to lead it. And I'm not sure that they're organized in that regard. And I think they need a lot of support from all sectors, from the private sector, from the government, from people in civil societies, from universities, because I think academia also has a lot of they have a central role to play, you know, from all our institutions really, because I think those industries, arts transcends differences in human beings, you know. We all like music. Yeah, the human race loves music. You know, I think of Jerusalema, you know, the song that brought the whole world together. I don't know where his copyright is sitting, because on the one hand, you can't take that away from the impact that song had on the world, and then at the same time, that value that it created is even more intangible than the song itself, you know. But the song and his copyright of it, I don't know what are they going to do with it. I don't even know whether I know recently he said that he's fighting for his song to make sure he gets something back out of the impact it had. But is he being supported by his peers in the industry, you know, and what can they do to help to support this guy? You can't hide him, you see, because he's just there, and it's such a nice thing to hook on and say, okay, how can we make a difference to help to change that?
The call has been made, Ambassador. You know what you've said in this answer is really, it's the call has been made, and you know, when you spoke about women in the creative space, you know, sitting in the margins as opposed to the center, and how we need to move from the margins to the center. I'm going to need to go home and meditate on that, because I've never actually heard it said like that, and it's so true. And I suppose perhaps I needed to hear it from yourself, you know, having traversed all these different industries, and yeah, it's quite incredible what you said there. And it's interesting that you make the example about Jerusalem when you're speaking about women, because, and I don't want to make this topic about that, but again, you know, it comes into question. It says, well, the woman who's involved in the song, it's not her, she just came and did the lyrics, but she didn't do this. So, you know, and again, you find women always trying to, you know, so no, but she did contribute, you know, and it's a never ending story. I see Chijioke's hand is up, and we have about 7 to 8 minutes before we take questions. Chijioke?
Okay, I just wanted to add to the conversation around women and representation of women in the creative entrepreneurial space. And in addition to what Ambassador has said, what I wanted to say as well is that, I mean, the question of gender equality, the fight for gender equality cuts across every sector and every, you know, area of our society. It's not just a copyright thing. It's not just a creative entrepreneurial space thing, but specifically to the creative sector. I think that a lot of the challenge that we're having is because our copyright laws, our intellectual property laws are gender blind.
Yeah.
So the laws don't take into consideration the fact that women and men have, the laws affect them differently. It's the reality of our society. It's the reality of every society. In 2019, I got funding from Open African Innovation Research Network to look at, it's like a huge funding from a Canadian research entity to look at Africa and to look at intellectual property laws from a gender perspective. One of the things that one of the focus of my research was on the collective management of copyright and how the regulatory framework is structured. If say for instance, just to give a quick example, if you have the collective management regulatory framework saying something like every collective management organization must keep a register of its members, full stop. That doesn't take into consideration that there are men and women musicians, for instance, in a music collective management organization. And the challenges that a male artist would face will be different from the challenges that a female artist will face. If you feel, for instance, that in a particular genre of music, say popular music, for instance, or even jazz, for instance, there are more male artists than there are female artists, how can you use that provision that says keep a register of members? Simple. How can you use that kind of provision to get more female artists into the conversation, into the industry, into the space? What of if instead of just having that, with the law or the regulatory framework said something like keep a register of members and ensure that the register designates male and female members or designate members by their gender? What of if the regulatory framework goes on to say if you're applying to CIPC for a license to operate as a collecting society, for instance, let us see your register of members showing gender, showing a gender disaggregated data. Let us see your plan for ensuring that female artists are better represented in that space. If you're going to give tariff rates to radio stations, for instance, what kind of incentive do you give them in terms of tariff rates to ensure that they play more musicians, for instance, than they play, or try to get a certain percentage in terms of the airplay that they give female musicians? So as much as we also need women, and not just women, men, everyone to be on board in terms of the fight for gender equality. We also need to think about gender, to think about how gender applies to our laws in terms of its interpretation, in terms of its application, in terms of its implementation.
Mm. Point taken, Chijioke. I think it's actually it's interesting that you say that, because oftentimes we mask over it. We don't actually realize, and we take for granted. And I suppose it also, you're right, it goes back to what the ambassador was saying as well, that when we see freedom, we see it in a masculine way. When we see power, it's in a masculine way. When we see, the law and the way that we, implement, we see it, it's got a masculine figure, right? And you're basically saying, even when we look at these regulations and policies, even around something like IP and copyright, that, it's still very much, maybe we still see it in a male in a male way. I don't want to take too much more time. I also do want to get our esteemed attendees on, and I did have one or two more questions to pose about the amendment bill and the digital spaces. But I see that some of the questions actually asked that already from the attendees. So I'm going to give a question out from Michelle. She says, do you think having more knowledge about how copyright protections work would level the playing field, right? So how do you think that the unequal negotiations can be improved? And lastly, how are the new digital platforms like Spotify affecting copyright protection and artists' earnings? And I was going to ask you, Chijioke, as well, because you've written and researched about the digital spaces. Could you perhaps speak to that question?
For digital platforms, I mean, digital platforms are like, they are the new marketplace for creative content. There's no way that any artist or any record label or music publisher is going to just operate from the physical space. In fact, that's being eroded, if not, you know, to a large extent, if not completely, by digital platforms. In the digital space, I think that what is key, which is the foundation of my book on multi-sided music platforms and the law, is to understand how copyright works. Chola has already explained to us, you know, copyright doesn't require registration. And so there's always the question of who has what, when was what created, and all of those things. For the music industry specifically, you have, you know, the creative process is something that I feel that can be easily captured by something as simple as, say, split sheets, where when you get into the studio, you have, you know, it's just like a one-page document where it just says this is the name of the person who production, you know, the music producer is this person, the artist is this person was featured, and all of those things, and you sign off. So that subsequently, when you then come up with your contract, your deed of assignment to say, I'm assigning, you know, my copyright in this work to so-and-so publisher or to so-and-so record label, for instance, nobody would argue, you know, regarding the way that, regarding who played what role in the course of creating the song. Moving to the digital platform, the issue is that as a copyright owner, as an author, as an artist, you know, as a person who created a musical work, you of course have the exclusive right to reproduce the work. You have the exclusive right to communicate the work to the public. So for instance, you can put your song on YouTube, on Spotify, wherever. Now, there's a difference between Spotify and YouTube in terms of the way the law works. So for Spotify, for instance, it's a music subscription platform. So you would be, as a copyright owner, you would be granting Spotify a license to put your music on the Spotify platform, right? And so in that kind of contract, you would have sharing formula in terms of how you're going to share and split subscription revenue that subscribers bring in. But YouTube and the YouTubes of the world have a different kind of arrangement, in that this is a user-generated content-based platform. I can upload any song I like on YouTube. Anybody can do that. But the question is, who do you go after if, as the copyright owner, you are not the one who uploaded your song on YouTube? And of course, YouTube has contractual arrangements that it has with what I would call a special class of copyright owners, who are essentially people that have like a large repertoire of music or of creative content. And so those ones have what YouTube call content ID. So it's easier for them to identify, to flag you know, when someone uploads without the consent of the copyright owner. The issue is, if I just have the one song to my name in my entire life, I may not be able to have a direct contract with YouTube. But of course, there's opportunity for me to enter into that kind of, into a contract with the person who can enter into a contract with YouTube. Bottom line is, and what I feel that as creative entrepreneurs, as artists, bottom line in terms of what I think we should wrap our minds around is in terms of what we should be thinking about is, there's no way in this digital economy, there's no way that as an individual, you know, speaking as a lone voice in this digital wilderness, there's no way that as individual artists, we are going to do much. Nobody is going to, it's difficult to have negotiations with 1,001 artists, each and every one of them. So we need to start thinking as a community. We need to start taking collective management organizations more seriously. We need to start reorganizing the way that our collective management organizations are structured, the way that they are regulated, the way that they work, because it is through organizations like that, it is through, you know, a community of artists coming together and speaking as one voice, that you can have conversations with people, with digital platforms that use creative content in a way not envisaged by the current Copyright Act that we have, which was not made for the digital economy. And that's just, you know, what it is.
I thank you for that, Chijioke. I have a question here, and I want to invite our attendees also to, you know, read the comments on the chat section. People are sharing some really valuable stuff on the chat section as well. But I want to read a question here from Ruth, and she says, regarding gender blindness in the IP legislation, I think this is a problem for many African countries. It may not be enough to simply amend a few clauses here and there. I would favor a complete overhaul of legislation so that gender considerations are embedded in the fiber of these IP laws and don't appear as just an afterthought. And she's asking, is this practical, or does the reality dictate that maybe the way to address these problems is through policy considerations and minor amendments? Chola, I'm going to tie this in with the question I was going to ask you about the amendment bills, because Ruth is speaking to the amendments, right? And I know that you've published your thoughts, you know, on, I think I read an article of yours in the Daily Maverick, sort of last year, on the amendment bills. Could you perhaps speak to Ruth's comment and kind of go, is it practical to overhaul, or, you know, are these amendments afterthoughts? And adding to that, why do you think those considerations lead us to where we are now with an amendment bill that's bouncing from the president to parliament, to the president to parliament? What is at stake here?
Sure. I think in the beginning, I talked about this balancing act between user and creator. And the whole thing about copyright is really trying to, and this is a gender blind response, how I'm beginning. It's designed to maintain that balance so that you can create, because ultimately, what do we want to do? We all want to make a living from what we do, regardless of what sector you're in. And it's important in the creative industries in particular for people to make money. And in particular, I think for women to make money, because, you know, you are sole proprietors in this space, and you create employment for other people, whether it be paying for session musicians, publicists, managers. There's a whole economy around a composer or an artist. And then when you have the money flowing in a particular way that it goes primarily to the men, women are unable to exercise economic rights and economic power in that context, and are still left at the mercy of men. So from that perspective, it's important not just to look at the legislation that's there, but also the ecosystem and the value chains within which we operate. So like an interesting thing is that looking at licensing and tariffs and saying we'll give you a preferential tariff if you play more music from female composers or female artists, whatever the case may be. So the interventions are at different levels. Now, back to my point about this balancing act is that what the Copyright Amendment Bill has done in its current form is that it's taken that balance and turned it on its head, and it puts balance in favor of the users vis-a-vis the creators. Because currently you have the exclusive right to do certain things or allow others to do certain things. I think the important one is the reproduction. And there's provision, there are exceptions within the Copyright Act, current one, called fair dealing, where it's very clear, listed in terms of what the exclusions are to that exclusive right that you have. The current Copyright Amendment Bill in its current form, and it suffers from the problem that a lot of legislation in South Africa has suffered from, is this transplantation of foreign things and then bringing them into our jurisdiction or our legislation and expecting it to work the way it works elsewhere, and then not adding some of the counterbalancing mechanism within that legislation here in our legislation, not taking into account our socioeconomic circumstances, not taking into account our history or anything like that. So what it's done is that it's put the users, given them the upper hand by including broad range of exclusions and exceptions, which will allow users to use content and then have the defense of saying it is fair use, because that's what we've introduced into this legislation with the amendment. We'll say it's fair use. So that means that licensing arrangements are jeopardized, because why must I take out a license and pay royalties if I can defend myself and say it's fair use? You know, it means that in particular, big users, big tech, will be able to use content and not pay, and drag you, a poor single composer, through the court system, if you can afford to do that, to prove that your rights have been infringed. And even if you do win, the most you can get out of it is what you would have gotten had your works been licensed in the first place. Whereas in the legislation in that jurisdiction, there are statutory punitive damages. So you can actually get millions if you win the case. So that's really what's at stake here. There's a threat to the livelihood of already impoverished South African creatives. And it just doesn't affect the music industry. And this is the sad thing, because when you go through a legislative process, the Constitution outlines particular processes which you must follow. And because there's an issue around trade and culture in this Copyright Amendment Bill, the legislators were supposed to have followed what we call a Section 76 process, which allows for broad consultation, would have involved the provinces being consulted. That didn't happen. It was only kept at a national level. So what ended up happening is that when submissions were asked from the public, it was the likes of myself in my suits and my fancy English that were able to travel to Cape Town and speak big, language and confuse parliamentarians. And they were not able to hear from the people who are actually going to be heavily impacted by this legislation. And the sad thing is that composers or creatives don't actually understand how this is going to impact them, because why? Again, the legislators did not do what we call an impact assessment study to see how this legislation was going to impact film, how it was going to impact music, how it was going to impact book publishing, how it was going to impact animation. They just didn't do that. So they drafted this thing, transplanted all sorts of things, didn't put in the requisite, counterbalances within the legislation, and they thought it was going to be a one-size-fits-all solution to fixing an old Copyright Act, which it needs to be brought into this century, because like has been said before, it doesn't take into account digital rights. So if it's not legislated, you can have platforms coming into this country wanting to use content, and you're trying to sign a license agreement with them, and they'll say to you, but those rights are not legislated. Why must we license for that? So there's a whole lot of things, that are happening with this amendment bill process. And I think part of the reason why it's been taken from pillar to post, I think in the first instance, is that the impact is on the creative industries, and the creative industries are not taken that seriously, in particular music. They really aren't. And that's why they approached it in the manner in which they approached it. And I think they thought they would draft something and it would quickly go through the system and be signed into law. And then, creatives in this country would have to deal with the courts and everything else that came afterwards. But I think what has happened, and it's not perfect, and there are lots of issues, and there's lots of contestation, even with the Performance Protection Amendment Bill, because there are tensions between performers and creatives. But what has happened is that I think a number of people have said, wait, this thing is atrocious. If you pass it the way it is, it's going to do so much damage to the creative industry. And there are also other broader economic discussions, because this has had an impact on trade relations with the US, but that's, you know, a discussion for another day. But really, it's going to impact that balance between creatives and users and tilt the balance firmly in favor, not even of users like you and me every day, or, you know, but firmly in favor of, in particular, big tech.
I have a question here, Chola. It says, so many women in the past have lost out on their IP due to unscrupulous industry players. So, and it's directed at you to say, how about a lobby getting CMOs to review women's IP ownership and give a window of opportunity to open their systems to correct the wrongs? Could you speak to that?
You know, in my personal capacity, I think that's something that's important. But I think the how is also an integral thing, because I think if you look at the structure of CMOs, the members who are the final decision makers, they're the stakeholders. So if you go to an AGM, they're the final decision makers on certain things. And I think if we can get, in particular, female members of CMOs to start pushing an agenda collectively to drive the CMOs in a particular direction, I think that's a good start, because you need to have that critical mass with a loud enough voice to say, hang on, I don't like this and I don't like that, and this is what I would like to see. And this is what I require from you as a member of your organization, because our business is very simple. We are administrators. We license, we are licensed for the use of your content. We then collect a fee. We take, a licensing fee from the users. We take our administration fee, and then we pay over to you. Now, I think what needs to happen in the music industry is that I think members and women in particular need to start understanding what their power is. And start utilizing that and start positioning that and start leveraging different platforms, because the field is ripe, the area is ripe now. We are talking gender-based violence, we're talking women's rights. Those conversations are happening now. They're topical. Decision makers are listening, policy makers are listening, legislators are listening. We need to strike now whilst the iron is hot. Look at our different environments, because you can do something in your space, but not necessarily in my space. But if we come together and use economies of scale and our resources, because a large problem also is the resources to enable, you know, fellow women to do certain things in different spaces, whether it's, you know, providing knowledge, an ear to listen, direction in a particular way. I think we need to start thinking in that way. And yes, there are a lot of victims. A lot of horrible things have been done to women in this and other industries. But we also have a strength that we don't realize that we have, and therefore we don't use it.
I want to perhaps bring Chijioke here on this question that says, you know, a lot of South African artists they're moving their, you know, the administration of their copyright from, you know, the Southern African Music Rights Organization, and they're going to internationals, sort of like ASCAP, PRS, SACM, you know, and the question is, you know, what is our experience of it? What is our thoughts and opinions on this? As somebody who has, you know, dealt quite a bit in terms of CMO legislation and regulation, what would you, if I change from SAMRO and I decide I want to, you know, register with ASCAP, is it going to make much of a difference to my life?
Yes.
Okay.
Yes, it will, because collecting societies are what we call juristic persons. They are artificial persons. So they have the rights that a natural person has. Collecting societies are established and regulated by the local laws, by the national laws in place for that collecting society within that country. So if, as a South African music copyright owner or copyright holder or author or artist, whatever, you are dealing with a collecting society outside South Africa, you are shortchanging yourself to a great deal, really, because you are dealing with a collecting society that is bound by and regulated by, you know, the law of the country in which that collecting society is set up. and those laws don't take into consideration your issues as a South African musician or as a South African artist. Whereas if you were involved with, or you know, work with your local collecting society, for instance, most of the national collecting societies, even in South Africa, even outside South Africa, belong to you know, like umbrella collectings, like CISAC, for instance, belong to umbrella organizations. They have reciprocal agreements with other collecting societies. And in that kind of, you know, space, they are able to negotiate from their own vantage points, because they are coming with and armed with the repertoire of, you know, the artists that are registered as members, whose works, you know, are managed and administered by that collecting society. I know, and which is what I told Danny Rusa that asked the question. I know that in South Africa that SAMRO has its challenges, for instance, you know, in terms of trying to trying to restructure and, you know, do things better. And it's a work in progress. What my opinion is that as artists, we must take ownership of the process as well, because, you know, we are, as artists, you're members of those collecting societies. We must take ownership of the process, and we must be more involved and make more contribution to how these things, you know, these things are done, and a bit of patience as well, you know, to see the process through. And the regulatory frameworks are, of course, in the works to be amended to also address the concerns that has led to, you know, artists and authors and musicians moving their work to other collecting societies.
Yeah. Thank you for that. Thank you for that, Doc. Yeah, and I mean, you know, we hear about these things, you know, and I'm glad you touched on the reciprocal agreements between, you know, the different CMOs. And I mean, I just think about it because when I was doing my research, you know, and speaking to the former chief economist of Spotify, this is last year, and the one thing he said to me, he said, do not underestimate the value of collection management organizations. And he said, you know, don't throw, you know, like it's, you know, don't throw the water or the baby out with the bathwater. He said, you know, there's power in the collectivity. And you're right, because you're saying you can't be in the digital space that each artist is going to talk to everyone by themselves. And so we need these collective, you know, these collective organizations. And you're right, you know, they're not perfect, but perhaps we do need a bit more patience. We do need to, you know, find ways to be a part of the process, to restructure them, and kind of look at ourselves and say, what can we do to add to that? So that really does tie in nicely. The one thing I wanted to do as we you know, come closer to wrapping up is the theme this year for World Intellectual Property Day is IP and SMEs, right? Taking your ideas to the market. And I thought, you know, it's such an honor and a privilege to have the ambassador, you know, make time to spend with us today. And I thought I would really like to, you know, as we wrap up, Ambassador, you know, we commemorating or observing Freedom Day tomorrow in South Africa. And the spirit with which we put this webinar together was to say, you know, are we truly free if we do not own our ideas, right? And kind of trying to look at it and think, well, you know, if we want to own a beautiful home, you know, a beautiful house that, you know, with an appreciating value, you know, surely when we think about our ideas, we need to value them equally, that, you know, we cultivate in our minds. And that's why we adapted land. And so I want to throw this final question to you, Ambassador, to say, how can we as creatives start to think of ourselves as SMEs, firstly, right? How do we think of ourselves as small, medium enterprises? And how do we then begin to take our ideas, you know, thinking of ourselves as SMEs or businesses? I know it's not easy for musicians to think of themselves as businesses, because ultimately ours is to create music, you know, and I had this attitude for a long time. I don't want to think about, you know, the knots and, you know, the rands and cents and invoice and now, you know, after going to business school for a while, now I'm like, sure, I need to think outside of the work, you know, the music. So as we wrap up, and in the spirit, because there are so many other webinars happening around the world this week to commemorate IP Day, and everyone is speaking to the same theme of IP and SMEs and taking our ideas to the market. How can we as Africans, you know, in the different spaces? I know you've got a book coming out, which is a compilation of stories, you know, from 60 women across the continent. And it says highlighting their work towards gender equality and making a difference in their countries. You know, so this book is, and, you know, and we wish you, we want to, I hope you're going to send us copies. We want to read it, you know, and, but it's going to fall in that as well. You know, that can we read it? Can I take it for UCT? Is it fair use? Is it fair dealing? You know, and so how can we think of ourselves as SMEs, our ideas? How do we take them to the market? I think you're muted, Ambassador.
Yes, this is a very important question that you ask, you know, Nomfundo, because I think let me tell my own story, because I think there are a lot of people who are on this call who will be asking the same question as well. When I started writing the book, I honestly didn't think about doing it as a form of business or even making money out of it, to be honest with you. For me, it was just a desire, because I've always wanted to write, and I thought, oh, let me do it this year, you know, because I turned 70 this year and I needed to give this year some meaning to my life. Because I've always wanted to do it. I thought, if I don't do it now, it'll never happen. So COVID kind of created the perfect conditions for being locked down in the house and inviting 60 other women to participate in the book. It is only as I was writing it and I realized, actually, you know what, I'm going to need some cash for this book, because I took money out of my little savings and put it towards the book. I had to employ kind of editors, you know, ghostwriters. Some of the women didn't have the time, and didn't have the desire to write, but they wanted their story to be told, so that meant hiring a ghostwriter. And as the thing unfolded, realized, you know, I just did not connect what I was doing with the business experience that I have coming out of corporates. It was just not the same thing. But I think when the penny dropped to say I needed the resources, I then started applying for money from various places, you know, the same corporates that I know, but also some foundations, and said, please, I'm writing this book, can you please support? And I had to make the gender case for it quite strongly. So, and I think that's where many of us start from, where, you know, you have the talent, or a lot of musicians have the talent. They have this voice in their stomachs or in their heads that says sing or write, or, you know, because that's how creatives are. Their motivation comes from within. It doesn't come from, the stimulus comes from within. And so immediately you don't think about yourself as a business person, you think of yourself as an artist, you know, and you only deal with the consequences of the money that you may need to create something afterwards. So I think we almost have to turn the whole thing around. And this is where I think our government and DTI and Department of Arts and Culture, for example, can come in. Why aren't there, I mean, I don't even know, I shouldn't say there aren't any specific funds from the banks in the private sector, a Sanlam or a FNB or any one of these big organizations that have special funds just for creative artists, like they have for people who want to go into other forms of businesses. You know, if you can apply to Sanlam for a fund for an SME, and they will give you the money provided you give them the right documentation that they need to say you can actually make this work. But I think we lack that kind of infrastructure that actually gives people the opportunity to be creative SMEs, to be creative businesses. They will need a lot of training, as you say, in this whole topic that we've just discussed this afternoon, so that they don't go into, it's a different set of laws, a different set of rules altogether for creatives than it is for somebody who's wanting to create a shop or wanting to buy a, what do they call, a shelled garage, or, you know, so on. So I think a lot of work needs to be done to say what do we need to be a business, a proper business person in this case. What's my product? How am I going to sell it? You know, in this case, the product will be a dance or a piece of music. How do I sell it, you know, on the market? look, America has done great with this. I mean, they really have a flourishing creative industry out of it. And we have so much talent on the continent. I mean, I look at these little kids who've been dancing across the continent to Jerusalem, you know. And these kids are so talented. They can dance, but their dance ends in the village, on the sandy streets of where they live. And I'm not suggesting by any means they should take away from there, but it ends up being played on virtually, on everywhere in the world. People are watching these little African kids dancing, but they are remaining as poor as they probably are. We don't know what happens to their IP, you know. So I think it's a big question, but I think it needs to be looked at from the point of view of the artists themselves. Is that what they want to do? Do they want to create an industry out of what they can do? If so, what do they need to do to get there? And secondly, how does our state see the potential of creative industries in this country? I think to a large extent, the visual arts are kind of making some inroads into this. You know, there's a lot being written about the visual arts, you know. People are beginning to appreciate artworks, and people are creating more opportunities. And it's also one area that is happening at a sort of Pan-African level. You know, you see how visual artists from Nigeria, from Ghana, from all over the continent are collaborating with one another, you know, to try and create a vibrant industry into what they're painting. And I think the other thing is just to learn lessons from what's been done in other countries. And I think the United States of America, outside of our continent, Nigerians are also, you know, you can see Nigerians are going for it, but they are go-getters, you know. They are making sure that it is becoming an industry there. I think South Africa is a bit slow for all kinds of reasons. And I don't want to play the blame game here. Nobody's being blamed. It's just that, you know, we're struggling a little bit to try and create businesses, proper businesses out of the talent that we have. I mean, these young kids who went to win, what are they called? From Mpumalanga, who won the competition?
The Indlovu Youth Choir.
The Indlovu Choir, you know. They're young people, but they have somebody completely dedicated to what they're doing. We need to do a little bit of research in there and see, you know, what are they doing to take this forward. I was recently involved with somebody who's created a school of music in Soweto, and they're doing another one in Khayelitsha. His name is Robert Brooks, you know, and he's just getting the talents from all over the townships, and these kids are playing violins and they're playing orchestral music, but they're also playing, you know, jazz and so on. But it's taken one person to sort of set up these institutions. And things like that, I think, need to be showcased a little bit more, and they are having opportunities to travel the world over to play. And I'm really talking from like 6-year-olds until they created the Miyagi Youth Orchestra. They're doing phenomenal work, but again, not many people know about what they're doing. But the talent is there. And how do you then graduate from doing that to it becoming something that people can actually make money from? It's a whole value chain. It doesn't happen first go. It's something that evolves with the creative side.
Thank you very much for that, Ambassador. What a great way to wrap up our proceedings this afternoon. And I think, you know, someone of your stature has really brought weight to this conversation in terms of just your, you know, not just your age. You know, when you said you're turning 70, I wanted to say happy birthday. Then I thought, oh, maybe it's not today, you know. And you know, and that we really are grateful for your time, and thank you, you know, to Chijioke and to Chola, you know, for bringing such incredible insights to this conversation. And I love how interspersed in the conversation, you know, you were saying, this is the issue and this is how we can begin to fix it. And I really like the spirit of not just kind of complaining, you know, but saying we've got to put things into perspective, right? And so now I've got a newfound understanding that, you know, these treaties and these regulations, because they're not just ours, you know, we've got international connections, but then when we bring them to the global south, it means something different. It's not copy paste. And, you know, Chola, you spoke about that as well. You know, when you spoke about the amendment bill, to say, well, if we're going to adopt fair use, it's an American concept. Why do we think it's going to work here?
Yes.
You know, and we don't have the money to litigate, you know, if your music or if your work is being used, you know, unfairly. And also, how do you define that? You know, we really went quite deep into this notion of how can women move from the margins to the center of the creative industry, right? We're coming to elections, you know, do we really just want to sing and earn the bit of money, you know, at the rallies, or do we want to know what's going on at the back? You know, how is the money moving? You know, what informs the transactions that really kind of that sit at the core of this creative industry? And so I think everybody's got some stuff to chew on, some tea to sip on, and to think about. And you know, also we spoke. Thank you, Chola, for that in terms of are we going to have this TRC? You know, are we going to have some kind of, you know, travel back? You know, yes, you did say, you know, Chijioke, that some of the things you can't do them retrospectively. Some of the laws you can't apply them, you know, the other way around. So a lot of things that really went on today. And I believe that this webinar was recorded and will be up on the Jazz Day SA site so people can revisit. And I'm sorry to anyone whose questions I was unable to take. But as a final word from me, again, thank you so much, everybody, for joining us this afternoon. And happy World Intellectual Property Day today. And good luck to each and every single one of you on all your endeavors. And hope to see you at the next webinar.
And happy Freedom Day to everybody tomorrow.
Yes, happy Freedom Day, everybody. Thank you so much, everybody.
Thank you.
Bye.
Bye.
It looks like we still have some we've still got 10 attendees as well. We haven't yet. Yeah. Are we staying behind, Brenda, Christine, to just, okay. Oh, thank you so much, Mandisa. Thank you. Mandisa Patil just saying thank you so much for a great afternoon.
Thank you, Christine. I was just saying,
Sis B, do we still have some guests on the? I think we still have, we've still got 6 attendees who are still with us.
we just want to thank everybody for joining us. Thank you, Andre, Tutu, Benjamin, Mandisa, Nomtusen. Thank you for staying on. Clearly, there's a need to come back with this discussion and more action-orientated next steps. And I think we're up for that, especially if we get inputs from everybody that participated and joined this webinar. Namfundo?
Yeah, just to, I mean, Edie, I will not speak on top of your words. You have said it all. You know, that 1.5 hours is never really enough to cover, you know, it's actually just a tidbit. It almost scratches the surface. It makes you want to put on your slippers and your pajamas and sit on this webinar the whole day, right? Because there's so much to cover, there's so much to talk about. But like I always believe that, you know, it's good to start the conversations and to have them be solution driven, without also overwhelming ourselves, you know. But I always find that the first conversation around a topic is really kind of a context giving one, which is why it's so important to have a follow up, because now, you know, now we're going to go home, we're going to think about these things, we're going to mull over them and go, okay, even if I thought that this was a way that we could approach it to fix it, now that I've had that you know, that conversation with these legal experts, perhaps I need to refine my thinking around what the solution could be, you know. So yeah, I really hope that we will have follow up you know, sessions around this topic, because I think for me today was really just about understanding it at just what is it? What is it? What are the challenges? And some really great questions coming from the attendees as well. The CMOs, women. Sure, that one about women, just like it's went in. When the ambassador said, from where she sits, women in the creative industries and in music, we prefer to be on the margins of the entertainment industry. We need to shift, and no one's going to pick us up and put us in the center. We need to find a way to travel to the center, like I need to go and sit with that.
One of the things that is equally frustrating is that every time we have to engage this, even on a daily basis of doing business and trading, every time the word IP copyright comes to play, there's an immediate tension. I consider it as a trigger, almost like somebody's already on the defensive. And I think if we understand that all this entire information that came through today, for instance, about the diverse, perspectives, we will be able to engage conversationally and reach agreements, with understanding of what we're handling. Because much as it's such a complex situation, it's going to take time to find the solution that will determine the way forward. In the meantime, the work continues, you see. So there's a lot of education that has to happen amongst ourselves as practitioners, as creators, and as people that trade within this space.
Yeah, but also, like, interestingly, I never really think about regulations or legislation, from this perspective of them being gender blind and how that is so problematic. That's why I'm like, today was so like, wow, for me, because I never think about, I think the law is the law, follow the law. The rules are the rules, follow the rules. I never sit and think, something's wrong with that law, because that rule doesn't take into consideration that, so yeah, is Mandisa saying we should start a female?
Well, I mean, this was a great challenge of saying,
yes, yes.
I was just trying to remember this question of saying, what are you going to do? I mean, for us, it's a big question coming out of this conversation. So I do believe there'll definitely be a revisit. And Nomfundo, when you jumped on this conversation, you did say the timing is right. And I think Ambassador emphasized it. And so did all the speakers. Women's lives matter, women's input matter. So it's the time for us to also take our place within discussions that matter.
Mm-hmm. And also just, that reality when someone says to you, it's not enough that you're just a good singer or good actor or it's not enough. That's hard, but that's so true. And it's so real, that because me being good at singing or doing, maybe that's what keeps me at the margin. Because in my mind, I'm thinking it's enough. And maybe the reality of the situation is that the world is moving so fast in the digital space because music and art is readily available. The trade of music is very different 2 years ago when you could only access good music through buying a CD. It's not like that anymore. When you stream one song of mine, I earn 0.0000032 cents. So maybe it's not enough. So I need to find a way to be in the center there. I thought what the ambassador said about that was the ultimate call, for me to say, guys,
it's not gonna come to you on a platter.
That's basically what the ambassador was saying. She was like, I'm not trying to cause trouble for you, but it's not gonna come to you. I appreciated that. It's not gonna come to you. So yeah, absolutely incredible.
Thank you, Nomfi. Thank you, Christine. Thank you, everyone, Mandisa, and everybody that's still hanging out. We look forward to your comments, and we'll make this recording available to everyone. I'm already getting messages for people that missed part of the discussions, so we'll make sure it goes through. Yeah.
Okay.
Thank you.
Okay, thank you, guys. So I'll end it on my side.
You're always the one to tell us when to go or when to work. Thank you very much.
Thank you. I'm closing the meeting. Take care, everybody.
Bye.
Bye.